Good afternoon, everybody. Thank you for joining us for another webinar event in ConMaciel Carey's annual OSHA webinar series. I usually can count how many we've done based on which month it is, but this year has had lots of interesting emergency type issues and developments. And so we've had a couple of bonus programs. So I believe this is actually our 6th webinar of the year, even though it is only mid-April. I hope many of you have been able to join us for all of the programs so far this year, and that you're able to join us for the rest of the year as well. If you miss any, we do have an archive of the programs recording and that are recorded, and would love to answer any questions you have about anything that you might have missed before, or anything else we have coming up the rest of the year. Today's program is an annual tradition where we get into developments at OSHA, California Division of Occupational Safety and Health. And there is generally a lot more activity and a lot more developments by OSHA than there are OSHA. It's a lot easier for them to promulgate new rules and standards under the state program than it is for OSHA to promulgate a new standard. So OSHA often leads the way, and there is lots to cover in discussing what's going on at OSHA, and this year, of course, is no exception. We'll do some quick introductions and then get into the content for today. To tell you a little bit about the first faceless voice that you're hearing from right now, I'm Eric Kahn. I'm one of the founding partners of the firm, and I chair the firm's national OSHA Workplace Safety Practice Group. This is my 20th year in practice, essentially exclusively in the field of workplace safety and health law. I practiced for a little more than a decade alongside the first general counsel of the OSH Review Commission, and have for the entirety of the 20 years now been representing employers in their dealings with OSHA and state OSH programs like, and in particular, OSHA. We help employers manage inspections, investigations, and the full range of litigation involving disputes of citations. Very pleased to be joined today by the two stars of our OSHA practice, Andrew Sommer and Megan Shockhead, and I'll let them introduce themselves, and then we'll get started.
Thank you, Eric. My name is Andrew Sommer. I'm a partner in the California practice for ConMaciel, and of course my practice is primarily centered around OSHA enforcement matters. And so in our office we will advise employers on inspections, investigations, and other workplace safety issues that involve OSHA or possibly other DOSH states, and then also defend, represent employers in appeals to the OSH board, and handle throughout the state negotiations and litigation of these appeals. I've been practicing a little over 2 decades, and my focus is in OSHA matters as well as traditional employment litigation. And now I'll turn it over to my colleague Megan Shockhead to introduce yourself.
Thanks, Andrew. Good afternoon, everyone. I'm Megan Shockhead. I am in the San Francisco office along with Andrew, and my practice mirrors that of Andrew's. I am closing out my first decade in practice, and I'm busy these days advising employers both on OSHA and other DOSH state safety issues, as well as other employment issues, and I'm also busy responding to various enforcement actions with OSHA as well.
All right, so on the agenda today was going to be a full program about enforcement trends and data, new legal developments from cases that have been decided, and new rules and upcoming rules that are working through the process in California. But then something rather dramatic happened. I'm sure you all are experiencing and managing and dealing with this crisis every day. COVID-19 has impacted the entire country, really the entire world, and certainly our workplaces have been affected in significant ways. So we are going to spend the first part of the discussion today talking about the OSHA implications of COVID-19 in the workplace. What are the OSHA specific regulations that will control some of our actions and responses and requirements as employers to manage potential exposures to the virus in our workplaces, but also some of the guidance and best practices that we're learning from others that could be useful for you to implement in your workplaces. And that includes Cal-OSHA's unique Aerosol Transmissible Diseases rule for the healthcare industry and other standards like IIPP and the Control of Harmful Exposures rule in California. We'll get into that. And then we will get into Cal-OSHA enforcement data and trends prior to this crisis and some other legal developments, most significantly a series of cases that impact requirements around protective footwear in a variety of different workplaces in California, in industries in California. And then finally, some of the brand new, relatively new, and soon to be new rules in California, like the amended injury reporting rule, serious injury reporting rule, the relatively new wildfire smoke inhalation rule, indoor heat illness, and general industry workplace violence. And so I'm going to have Andrew lead us off talking about the COVID-19 in the workplace issues in California.
Thank you, Eric. As Eric had mentioned, given all of the legal issues emanating from COVID-19, that has been a frequent source of our advice to clients and the guidance that we've been following. So what we wanted to do was, we could have a whole Cal-OSHA webinar on this subject, but we're going to touch on all the major areas legally impact COVID-19. And so to start off with, we wanted to talk through some of the Cal-OSHA standards that are potentially implicated. And we'll go through each one. The different standards that are potentially applicable here are the Aerosol Transmissible Diseases standard that applies in the healthcare context. Also, the Injury and Illness Prevention Program requirement that is very broad and impacting essentially every industry in California. And then also the standard for personal protective equipment, whether that be gloves, face coverings, other protection, and the control of harmful exposures in the workplace. And lastly, the ever-present subjects of reporting and record keeping in California. So what we have in California is we have the framework of all of these different standards, but it's not necessarily the case that that all of these that COVID, there's not clear guidance on how COVID-19 fits within all these standards. And there recently was a interim set of guidelines that were promulgated by Cal-OSHA, by the division, and they have posted on their website. And if you go to their website, you'll see, and actually I was going to note, there was a very wise comment. I referenced face coverings, and someone had noted that that is not PPE, and that is correct, it is not PPE. We could be talking about respirators or other forms of protection, so let me correct that. But turning to the guidance that has been issued by the division, there is a guidance document that's on the division's website, and there are a number of documents there that concern specific industries and are very generalized in nature, as well as just guidance that can pertain across the board. And this guidance, just note, is evolving. And there are postings on the division's website that go from March all the way through the present. And there you will want to keep track of these developments. The information we're providing based on these guidelines is current as of the present date, April 16th. But turning to, so just going back one second. So this, they have a guidance document that addresses various different areas. And within that document, they do discuss principally at the outset the Aerosol Transmissible Diseases standard. And we could have an extensive discussion on this, but I did want to cover this standard in a nutshell, just so that you can be clear on whether it applies primarily to your industry. And so this standard concerns essentially the transmittance of infections, which can be particles or droplets through inhalation as an example. And so this standard is fairly detailed, concerns certain specific industries, and those are enumerated on the slide here. It can be hospitals, nursing facilities, clinics, medical offices, home health care, long-term health care, hospices, medical outreach, EMT. Then you also have laboratory settings under certain circumstances, corrections facilities, drug treatment programs. And then other than what is specifically listed here, it would be any locations that Cal OSHA informs in writing must comply with the rule. So unless you've been instructed otherwise to comply, you have to be one of the categories of healthcare organizations that's listed in the standard. And so briefly, this rule is divided between two different categories. There's treating facilities, also known as full standard employers, and then there's referring facilities. And so there are numerous components of the ATD procedures that are required, but in essence, a referring employer is required to meet certain requirements, and a referring employer means essentially an employer that screens patients for airborne infection disease, refers cases of airborne infection disease, and provides no further medical services to these cases. And that referring employer also does not provide transport, housing, or isolations of persons with airborne infection diseases. And so a referring facility must comply with specific requirements, including administrative controls to reduce risk of transmission, reduce risks relating to cleaning and disinfecting. And then for a treating facility, that's typically essentially a full standard employer that provides diagnosis, treatment, and other services to patients with airborne infection diseases. And they're required to have a ATD standard that's detailed, and we list here a number of different categories that they need to consider in terms of screening, record keeping, engineering controls, medical services, PPE, et cetera. And we will provide a copy of these slides after the webinar. But because we have so much to cover, I wanted to focus some time on employers that are not covered by the ATD standard. And so you'll know if you're covered by ATD and have to comply with the very rigorous requirements under that standard. Otherwise, under the recent Cal OSHA guidance, they're recommending that employers not covered by the ATD rule, that they follow the CDC recommendations. And the recommendations, it's called the Interim Guidance for businesses and employers to plan and respond to COVID-19. And so the position of Cal OSHA is that those are best practices, and following those guidelines would be considered reasonable from a Cal OSHA standpoint. And some of the factors that are described by Cal OSHA are in the CDC recommendations. They include signage and communication with employees about hygiene practices. So that could be, for example, the proper etiquette for coughing and sneezing, the identification and of workers that are exposed, and keeping sick and exposed workers out of the workplace, having a procedure policy for that, implementing telework policies and restricting visitors where possible, also having policies and procedures over the proper physical distancing, and limit workplace concentrations, consider staggering and rotating shifts, providing an adequate supply of alcohol-based hand sanitizer, cleaning supplies, hand soap. Also questions of housekeeping around sanitizing as an example. discouraging the sharing of phones, desks, offices, tools, and equipment, canceling, postponing large meetings, and otherwise just implementing engineering and administrative controls. So which elements
Andrew,
you focus on? Oh, yes.
Yeah, say I could just fill in some of the gaps around engineering and administrative controls that we're seeing, either federal OSHA recommend, CDC recommend, or that we're just hearing about from the field that are effective here. The concept is about, implementing that social distancing. When we're all kind of teleworking and sitting in our homes, that's the kind of perfect degree of social distancing. But if you have, one of these essential businesses where employees have to report to a brick and mortar workplace, then consider the kind of engineering and administrative controls that can maximize that social distancing in the workplace. Like if you have workstations that are set up right next to each other, either reconfiguring to move those workstations apart, or if you can't do that, considering some sort of barrier between them, like a plexiglass shield. I mean, you've probably all seen now at the grocery store, the sneeze guard plexiglass shield between the point of sale personnel and the customer. Doing something like that between two employees on a manufacturing line would serve the same function. Other things that we've seen in terms of engineering controls are talking about the air quality in the workplace and the air movement in a workplace. Oh, so I'm sorry, you did have a slide on this. I wasn't sure if that was part of this or not, so I'll let you jump back in and take the controls on that. My apologies.
Eric, you can steal my thunder. That's fine.
No, it's fine.
Eric was mentioning some of the engineering and administrative controls, and Eric summarized those well. And so essentially, in terms of the engineering controls, we see in the grocery stores and other retail locations where there may be a plexiglass barrier between the employee and the general public. That is a good example of an engineering control. There's also examples of improving the air filtering system, if there's a system in place that would control exposure to a degree. But I think what we're seeing most would be physical barriers. There's also examples of placing taping to have members of the public appropriately distanced to ensure the necessary separation. For administrative controls, you could look at requiring, of course, sick workers to stay home, having virtual meetings, rotating shifts, having fewer individuals in the same workplace as feasible, and requiring face coverings. For safe work practices, we're looking at considerations that are kind of relevant to many businesses, such as reducing duration, frequency, intensity of exposure, requiring regular hand washing, sanitizing, and then, of course, PPE. There was the recent guidance by the CDC recommending face coverings for the general public. And so we are seeing businesses now, based on that guidance, considering face coverings and making them available to employees. So this would be something that wouldn't be a respirator, but something that would provide some degree of protection for employees. So
there's a really good question that came in.
Okay.
It's timely on this slide. The question is, in a manufacturing setting, or really any setting, how do you enforce not sharing tools? And that's a great question. And I think the concept here, the guidance from CDC and from OSHA and from Cal OSHA is all about identifying those things that are feasible and possible and effective in your work environment. And so if there is, a truly special and unique tool that you don't have multiple forms of the same tool in your workplace, then what you're going to try to do is limit it to the number of people that have to use it, right? You might change some of your staffing decisions so that fewer people, maybe only one person has to use that tool, but if multiple people do, that's where you're going to go to things like your enhanced housekeeping and sanitation program. And you're going to, look to, there's a list that EPA has produced of approved cleaning chemicals that are effective on the COVID-19 virus. And so you'll do more frequent cleaning. And so if you're going to go from one person to another working on the same machine or using the same tool, then that's where you're going to utilize a cleaning protocol in between those uses. But if there is a way to reconfigure your work schedule or to obtain additional tools so that you don't have to share the tools, then that would be the kind of solution that OSHA would be looking for. And on the face coverings issue, we've included it, you'll notice, listed under the administrative controls bullet rather than the PPE bullet, because a face covering, like the do-it-yourself variety that the CDC has put out instructions about, or the scarf or the bandana, or even the loose-fitting dental, surgical, paper and cloth masks, really are not designed to protect the wearer of the mask. They're designed to protect other people from secretions by the wearer of the mask. And the reason why it's recommended in workplaces is because my mask protects you, your mask protects me. So if we're all doing it, that's why it's not PPE. That's why it is a control, though, either an engineering or an administrative control, as a way to mitigate some of the exposure here, because you're keeping your secretions, your aerosolized droplets of that may contain the virus from going out to other people. And that's why it's recommended now. In fact, that's why it's required by some departments of health and some governors around the country now. And I'm at the point right now where I think we are either very close to or already at the point where that would be viewed as essentially a required aspect of your infection control plan, by Fed OSHA under the General Duty Clause, by Cal OSHA under IIPP, because it is at this point such a pervasive recommendation by medical authorities, and even in some places mandatory for literally anyone who goes outside the home into public is required to wear some sort of face covering. So I think that's something to really seriously consider now for all employees.
And that's a good segue into the Interim Illness Prevention Program standard. And just to reiterate, all of these different considerations about engineering controls, administrative controls, PPE, and looking at it from the vantage point of the CDC recommendations, it's essentially a recommendation. In the guidance document from Cal OSHA, they're making recommendations that you follow these guidelines. And so it's not mandated at this point, but what can happen is you can be cited for an Interim Illness Prevention Program violation. And in their program guidance, in their guidelines on their website, Cal OSHA essentially gives you a list, like what we did at the outset of this subject, about all the different standards you could be cited under. And so the one that's most problematic that I see coming up in a broad base of industries is the Interim Illness Prevention Program rule. And as many of you know, California has its own IIPP rule, and it's in some ways similar to the General Duty Clause under Fed OSHA, and in other ways worse. And it essentially, as relevant here and as noted in the interim guidelines by Cal OSHA, it requires that an employer determine whether COVID-19 infection is a hazard in their workplace. And then, which, I think the answer is going to be yes for most, and then look at where it is a hazard, that employers must implement measures to prevent or reduce risk of infection, such as implementing the CDC recommended actions. So what will be important here in terms of avoiding an IIPP citation, and for the benefit of the workplace, of course, too, is having a hazard assessment that you've conducted. And it's something, that I would personally recommend documenting and showing that you've considered the various different COVID-19 related risk factors in your workplace, and then what measures you need to take, whether it be administrative controls, engineering controls, PPE, et cetera, to kind of mitigate those risks. And so you should have, ideally, an action plan that you've implemented as a result of that hazard assessment of what measures you're going to take, and then also provide training. And that's a really critical one. There's a number of workplaces presently where they have instituted measures, but the employees don't really understand what those measures are, what's being done, what the expectations are. So a training is a really key consideration here. And then Another standard, of course, that comes up is the Personal Protective Devices Standard. That's 3380. And it requires employers to conduct a hazard assessment to determine what workplace hazards are present and necessitate the use of PPE. And PPE can be broad. It can relate to protection for eyes, face, etc. And after you conduct the assessment, you'll need to conduct training and need to evaluate when a PPE is necessary, what type of PPE is necessary, and then have procedures. So for the selecting, maintaining, storing, and cleaning of the PPE, and then to ensure that each worker is trained on the requirement on using PPE. And as Eric mentioned, face covering is not PPE, but a respirator mask would be. Okay, I'm going to turn it over to Eric on control of harmful exposures.
Sure. So this is another, California unique regulation, the Control of Harmful Exposures Rule, which is designed to protect employees in California workplaces from dusts, fumes, mists, vapors, and gases that are hazardous or at hazardous levels that they may be exposed to in the workplace. I view this standard as, oh, we just jumped ahead a little bit, Andrew, on the slides there. The
right now.
harmful exposure standard is akin to, under the Fed OSHA regulatory scheme, sort of the chemical specific standards out there. And Fed OSHA has slogged through and generated over the course of, it takes about a decade or two to promulgate a chemical specific standard one at a time. But California has put together this rule that covers generally any of those types of harmful agents. And Cal OSHA has come out in the wake of the current pandemic and said explicitly that COVID-19, a virus like COVID-19, is a harmful exposure, is a potentially harmful inhalation exposure that is covered by 5141. And so, similar to sort of the PPE hazard assessment to identify whether respiratory protection is required, this standard requires you to take a look at that harmful inhalation exposure in your workplace and identify whether there are engineering controls that are feasible, that should be implemented, that would reduce or eliminate the exposure to that inhalation hazard, whether there are administrative controls that are practical that can be implemented to reduce that exposure to an inhalation agent like this virus, and whether respiratory protection is appropriate and what type of respiratory protection may be appropriate to respond to this. So these are ways that in California, unlike in federal OSHA states and other states, the Cal OSHA can look to your response to this pandemic and say, you've fallen short in certain ways, whereas Fed OSHA has to use the general duty clause, which is a tough climb for Fed OSHA to establish violations under the general duty clause, looking at general guidance from CDC and OSHA about engineering and administrative controls. Cal OSHA has a specific regulation here that would require you to take those steps. So it would be, I guess I'd say, easier for Cal OSHA to enforce a insufficient response to this crisis in California than in other parts of the country. So you've got to take, I think, a really careful look, and I think you can do this anyway, and every employer I know is doing this anyway, but a real careful look at what is feasible to do in the workplace to address this hazard. Other big regulatory issues that we're seeing impacted by the COVID-19 outbreak would include, I think the next one is record keeping, and lots of questions on the next slide if we can advance the slide. Lots of questions about whether COVID-19 cases are recordable, are reportable to Cal OSHA, and in what circumstances they're recordable. We just recently saw a letter written by Doug Parker, who's the head of Cal OSHA, to an industry group answering some questions about record keeping and reporting. And here's what he had to say, and it is consistent with our understanding of the regulatory scheme in California as well. And that is that record keeping in terms of what is a recordable injury on your Cal OSHA Form 300 log, the Cal OSHA recordable requirements align perfectly with the Fed OSHA recordable requirements. So from a record keeping standpoint, the chief of Cal OSHA has said that Cal OSHA is going to defer to Fed OSHA guidance about that in terms of recording COVID-19 cases. And so what Fed OSHA has said about this is that to be a recordable case, well, first they've said COVID-19 is a potentially recordable illness, whereas the cold and flu are expressly exempt from record keeping by regulation in the Fed OSHA scheme and the Cal OSHA scheme. Fed OSHA has come out in guidance and said COVID-19 is not the cold and flu. It is a different virus, and therefore it is not expressly exempt from record keeping, and we are not going to just wave a magic wand and pretend like it is the cold or flu and therefore make it not a recordable illness. It is recordable, but it's only recordable if it meets one of these three criteria. It is a confirmed case, and being a confirmed case means that there has been a positive test by a fluid specimen. And it includes, though, if you look carefully at the guidance, it includes cases that are under investigation, but they're under investigation at least because they have at least one positive test, even on the quick result test methodology. So truly a confirmed case. Without a confirmed case, you're not going to be dealing with a recordable. If it is a confirmed case, then you look to whether it is work-related. And the reason why the cold and flu are expressly exempt from record keeping is because it is extremely difficult to determine where and how someone contracted the illness. And the same is true of COVID-19, but we are tasked with making that assessment, determine work-relatedness. And the standard is it more likely than not that an exposure in the workplace was the exposure that caused you to contract the illness? And that is a really, really difficult standard to meet. So difficult that Fed OSHA just issued additional guidance on Friday, a few days ago, this past Friday, saying that because it is so difficult to make that assessment while there is ongoing community spread, while the numbers are growing like they are all over the country, in the home, in the grocery store, out on the street, the exposures can happen, and it is very difficult to determine whether it was work-related or not. OSHA came out and said, if you are in the healthcare industry, the emergency response industry, right, you are transporting sick patients to the hospital and responding to and helping to serve the community in an emergency response capacity, or in a correctional facility type of environment and workplace. For those industries, OSHA expects you to do the detailed case-by-case investigation to assess whether it is more likely than not that a work-related exposure was the cause of the illness. But if you are not in one of those industries, Fed OSHA's guidance essentially says, and it's poorly worded and it can be confusing on paper. What I understand from discussions with senior leadership at Fed OSHA, the concept is if you're not in one of those high-risk industries, you essentially don't even need to undertake the work-relatedness analysis unless work-relatedness is just slapping you in the face. It is just so obvious because it is a big number of employees, in your workplace are experiencing positive tests, and there's not other explanations for that analysis. That's Fed OSHA's discussion right now. California has said, and this guidance, this letter that we saw from the head of the agency has said that because record keeping is the same in California and federal, that we are following Fed OSHA's guidance. That instruction that we're following Fed OSHA's guidance came out, I believe, before this most recent Fed OSHA guidance. So I don't know for a certainty that Fed OSHA is taking that same approach, that it is essentially presumptively not work-related in industries outside of healthcare and similar type of agencies, or similar type of industries. But that's where Fed OSHA is now, and there is at least some indication that Cal OSHA intends to follow that. I would not be terribly surprised to see a total reversal on that in California, where they come out at some point and say it's presumptively work-related if your employees are at work. But until that time, it is not going to be recordable unless it is obvious, because there's a cluster of cases with a lack of alternative explanation. So that's the recording side. The reporting side, I think that Andrew is going to cover, is quite a bit different in California than it is in Fed OSHA states.
Okay, thank you, Eric. And before proceeding with reporting, there were a few questions about hazard assessments and whether those needed to be separate documents, whether they could be part of the Injury and Illness Prevention Program document. You can prepare the hazard assessment in a number of different ways. You can certainly combine in a single document various different related hazard assessments, and the hazard assessment does not need to be part of the Injury and Illness Prevention Program, and it may be preferable not to have it as part of the program, because when Cal OSHA comes back, they usually look at your program document and do a check-the-box exercise to make sure you're in compliance, and you might not want to have that, potentially cluttered with other unrelated documents. But anyway, wanted to proceed with reporting, and to the dismay of Eric, among other Fed OSHA practitioners in our firm, Cal OSHA is so different on reporting, and that we have a component that provides for reporting, a requirement to report when there is a serious injury, illness, or death that occurs in a place of employment or in connection with any employment. So the connection with any employment prong is work-related, and that makes sense to most. But occurring in a place of employment, it's a no-fault component. It's not related to the actual duties being performed. So I wanted to start off first with the in connection with any employment prong, and that is anything in the context of COVID-19, that would be essentially an employee contracting the virus in connection with work, regardless of when the symptoms arise. So you could have an employee at work that contract COVID-19, and then they have symptoms some days later. They're in that same informal, unpublished opinion by the division division chief. He gives various examples of what might show this work-relatedness, and that could include multiple suspected or confirmed cases among workers who work together or commingle at a job site. And I believe that is consistent with Fed OSHA. There was also a reference by the division chief to the situation where a diagnosed worker has regular work-related close contact with the general public. There's a question about if it's healthcare, would they presume an exposure in the retail setting? If you do have some close contact, would that be enough to conclude that there's a work-relatedness? And this is not the law. This is an opinion by the division chief. And it's important to note that the illness may be reportable where symptoms were experienced away from work after working. And so, this would typically be a situation where the employee is working for a number of days, tests positive for COVID-19, then develop symptoms, and based on a cluster of cases at work or very close contact with the general public, is the question of whether this would be considered work-related. The other situation where an illness could be reportable is whether it just occurred in the place of employment, and it requires the reporting of employee injuries or illnesses and fatalities which occur on an employer's premises, even if they're not work-related. And so there can be the example of someone that arrives to work, has a heart attack, and passes away. That fatality is not, apparently work-related by any means, But just the fact that that person had a fatality on the premises in the workplace would be sufficient for reporting purposes. Under the second bullet or arrow, it's important to note that Cal-OSHA requires that any doubt about whether an injury, illness, or fatality is related to the workplace, it must be resolved in favor of a report to Cal-OSHA. And so if it is a gray area, it may be a situation where a Cal-OSHA could come out and cite you, even if there's some ambiguity there. And then there's the issue about what if an employee develops COVID-19 symptoms before the regular workday, and then the illness becomes aggravated, and then that person is transported to a hospital, and as a result, that triggers a reporting, or that would make it a serious injury that's potentially reportable. There can be some debate whether that would be a reportable event. And just for background, essentially for reporting purposes, a serious injury or illness is one that requires, in this context, what would be most relevant would be an inpatient hospitalization. Otherwise, it could be a fatality. And so there is no clear guidance or by the Cal-OSHA Appeals Board on what would happen if you had these kind of evolving symptoms that accelerated in the workplace and then resulted in hospitalization. But there can be an argument that under that situation that illness that previously manifested itself prior to the workplace but required the hospitalization, the transport to the hospital while the employee was in the workplace or resulted in a fatality in the workplace, that's something that could be reportable. And so wanted to point out that there are a number of guidance documents on the division's website. And so if you're an agricultural employer, there is a brief guidance document. There's one also for child care programs and long-term care facilities. It may be that in the coming weeks there'll be more guidance for different types of industries. Actually, there was one recently added that's also for grocery employers and some guidance there on measures that should be taken or at least recommended. I want to also walk through some Cal-OSHA enforcement trends. As we've covered previously, there are certain standards under Cal-OSHA, and I'm segueing out of the COVID-19 framework for a moment, but there are a number of different standards under Cal-OSHA that are frequently cited, and we wanted to alert you to these standards. And this is something it's important to keep in mind also if you're negotiating with the division in settling a citation, to really look at which standards you may have some heartburn over accepting given the potential for a repeat violation down the line. And so we have the Injury and Illness Prevention Program. That's one we see all the time. It's essentially, if they can't find a standard directly on point, they're going to try to cite you under the IIPP standard. Also, heat illness, that is a priority standard for Cal-OSHA. So if you are an employer that has workers working outdoors, that is an area where when they do come to inspect, they're going to ask for your heat illness prevention program document, and they're going to ask questions to ensure that you've complied with the components of that standard and potentially cite you. Another very common standard is the reporting standard they just covered. That's cited frequently, as well as the hazard communication standard relating to essentially disclosure of information about hazardous chemicals in the workplace. Then there's also the lockout tagout standard for machinery and equipment. That standard is frequently cited and is also frequently, unfortunately, a source of workplace injuries. There's a respiratory protection standard that's a frequently cited one. And then for portable ladders, interestingly enough, that comes up often. There is a portable ladder training standard. And that's cited quite often. Also, there's situations where the ladder might not be technically compliant, and that the employer could be cited under the portable ladder standard. And so let's cover some enforcement data. Cal-OSHA is one of the more aggressive Fed OSHA plans and state plans, and there is some data that has been circulated about its enforcement activity. And what we have seen is, a fairly high volume of inspections, and whether that be letter requests or on-site inspections. But in terms of the actual investigations, we're looking at between 13 and 15,000 investigations per year of businesses. About half of the inspections, half of the investigations involve inspections, whereas the other half are typically letter requests. We're seeing a high volume of these investigations resulting in inspections. And just anecdotally, we're finding that if Cal OSHA comes out, they investigate your workplace, even if they find that the focus of their inspection does not result in a citation or warrant a citation, they might find some other issue. It might be sort of an Easter egg hunt where they find something else that they cite you over. So, the vast majority of the inspections are resulting in citations. We are seeing the statistics are that per inspection there's between 2.3 and 2.9 violations that would result in citations. We're seeing that the serious violations are between 20 and 25% of the overall citations that are issued. We saw an uptick in investigations in 2017, and then there's been a little bit of a reduction in 2018. There is a shortage of co-shows in Cal OSHA right now, and they did have a hiring freeze. They're back to hiring. They're hiring co-shows as well as an attorneys. So I would expect in the coming years for us to see a further uptick in the number of investigations and resulting citations. Some takeaways from this data is if they come out to inspect you, they are likely to issue a citation, and that if they are going to cite you, it's the odds of receiving a serious citation the odds are pretty high, and that I would expect these numbers to increase in coming years as hiring resumes at Cal OSHA, based on the number of investigations as well as citations. And we are seeing some uptick in penalties, and the penalties at Cal OSHA have increased significantly in recent years, and that's another consideration. And so I will just briefly discuss some top legal developments, and then I'll turn it back over to Eric. But there have been some court decisions in the last year, and there were two in particular I want to discuss with you that concern protective footwear. And the first one is the Home Depot decision. In a nutshell, just to explain how this works, is that if there is an appeal before Cal OSHA, you can take the matter to a hearing with an administrative law judge, and that ALJ will render a decision. If you're unhappy with that decision, or the other side is, they can appeal it to the appeals board. That's the overarching entity. And then if one side is not pleased with that outcome, they can then appeal it to the Superior Court, and then from the Superior Court to the Court of Appeals. And so there are some matters that do make it through all these different levels, and Home Depot is an example of that. That made it all the way up to the California Court of Appeals. And unfortunately, the Court of Appeals affirmed the board decision that does, raise some concerns about the need for protective footwear in certain settings. And so essentially that decision covered the requirement for appropriate footwear or foot protection under Section 3385A. And this was a warehouse setting. It was a distribution center, I believe, where there was an allegation of potential exposure to foot injuries. And in that case, Home Depot required just closed-toe shoes or closed-heeled shoes for warehouse workers, and didn't require any sort of cap or steel-toe boot. And so it's important to note, I think a really key takeaway in this case is that the division is laser focused on warehouse environments, whether they be wholesale or retail, about the need for protective footwear. And so here they asked for the hazard assessment. They weren't pleased with what they saw. Then they did their investigation and essentially concluded that there was a risk of foot injury that was not being met. And so just briefly, under 3385A, essentially you're required to have this appropriate foot protection where the employee is exposed to falling objects or crushing or penetrating actions that may cause injury, among other possible scenarios. And here, what was significant is the appellate court ruled that there was substantial evidence that the warehouse workers who lift heavy items and are on foot and in close proximity of the pallet jacks as a normal part of their job were exposed to foot injuries. And so this whole idea that by lifting heavy objects that you can be exposed to foot injury from the object potentially falling on your foot, that's not new. And there's been board decisions that have addressed that issue. But what is in a way new or newish is this issue about the pallet jacks, the lift operators. And basically what the court did and the board did and what was affirmed on appeal was find that that the employees on foot in the warehouse were actually exposed to foot injuries in their zone of danger. And so the zone of danger is the area of the hazard that's accessible to that employee. And so what the facts that we had in that case involved purported evidence that the lift trucks were just maybe between a half a foot and a foot from the employees that were walking the warehouse. And they found that because the forklifts were in the zone of danger for those warehouse workers, there was a requirement that those warehouse workers wear protective footwear. And so it is one thing to note in this decision is the division is going to assume that there's a requirement in a warehouse context to have warehouse workers, everyone including the lift driver, to wear these protective footwear, whether it be steel-toe boots, boots with a cap, etc. But what's important from a defense standpoint going forward is to make sure you have a hazard assessment, that you considered administrative and engineering controls to mitigate any risk, though that alone might not be sufficient, and that consider what type of separation you can have increased separation between the lift driver and the warehouse workers, and then ultimately whether you should require protective footwear. So let's segue, and I guess lastly, the second element is just that the American Society for Testing and Materials standard is the one that is presumed appropriate for the type of protective footwear that is provided. And then the last court decision that I want to discuss, and this will be fairly brief, is that there has been recognized a requirement in California for employers to furnish safety devices, to provide them where they are required to ensure a safe workplace. And so there's two labor code sections that are cited on this slide. It's 6401 and 6403. And so essentially it's a requirement to furnish and provide these safety devices, and that has been read to include protective footwear. And so in this decision, UPS maintained that it was not obligated to pay for the employee's foot protection. They raised a number of different arguments. They were shot down by the appellate court, and the appellate court found that the safety devices includes protective footwear and that the employer is required to pay for this protective footwear. And then the court essentially found that the employee was on notice of the need to furnish this protective footwear. There's a seminal California Supreme Court case, Bendix, that addresses this issue. And essentially, if you have employees that are required to wear protective footwear, you'll want to ensure that they are furnished this footwear at no cost. And there's a number of different ways you can go about this. You could just provide them the footwear. You could send them to some sort of shoe store or other off-site location where they can obtain their footwear at the employer's expense. Or you can provide some sort of stipend to employees that's reasonable, so it's enough for them to buy this footwear. But a really important consideration, too, is that you ensure that these shoes are replaced when they become worn at the employer's expense. Let me turn it back over to Eric to discuss the amended reporting rule.
Yeah, we've had you for almost an hour now, so I'm just going to move very, very quickly, high level, for a couple of new developments in California. The first is the amended reporting rule. We'll flip over to the next slide there. Historically, Cal OSHA's reporting rule has defined serious injury or illness as the type of injury or illness that needs to be reported as requiring hospitalization for 24 hours or more, or an outcome that results in the loss of a member of the body. And it also has included this serious degree of permanent disfigurement as part of the definition. It also historically excluded intentional assaults, workplace violence, as potential reportable events, and excluded most automobile accidents from reporting. What they did in the summer of summer of 2019, was make some changes to the reporting rule to better align it with the Fed OSHA rule. As we talked about earlier in the context of COVID-19, it is still not perfectly aligned because there is more than just work-relatedness. It's something that occurs in the workplace, and Fed OSHA has certain time limits that California doesn't have. But otherwise, there was a general effort to align the concept of what types of injuries and illnesses are reportable to California. So what they did was, instead of that 24-hour stay, they did, just like they have in Fed OSHA, the requirement for an inpatient hospitalization for medical treatment, something beyond diagnostic, beyond observations or diagnostic testing is enough to trigger the reporting, even if it's less than 24 hours, which really doesn't ordinarily happen. If you're admitted, you're ordinarily there for that duration anyway. But it's that inpatient admission to the inpatient service, which is key. And there are some instances where you might be at the hospital for an extended period of time, but not ever be admitted to the inpatient service in the emergency status for an extended period of time. And under the Fed OSHA rule, that's not reportable. Now, under this new rule, it is also not reportable unless it meets one of the other criteria. So the other changes that they made, they changed that language that previously talked about loss of a member and aligned it better with the Fed OSHA rule to use the term amputation, which in the Fed OSHA jurisprudence, you look to the language used by the medical professional. Is it a laceration? Is it an amputation? Is it a partial amputation? Looking to medical guidance for whether that specific precise medical term is met by the condition of the employee. They also added loss of an eye as a specific type of reportable injury. Ordinarily, that is otherwise going to be reportable from the other criteria, but it is a requirement under the Fed OSHA rule, and Cal OSHA adopted it as well. And finally, they dropped the exclusion for those intentional assaults, violations of the penal code that might result in a serious injury. Those are covered now, and that makes sense because in the intervening years, Cal OSHA has promulgated a workplace violence standard. So you would have a regulatory requirement to address that hazard, but not have to report that something happened as a result of that type of hazard or conduct. Did not line up well with the direction that Cal OSHA was going in treating workplace violence as a regulated hazard under their scheme. So those are now reportable if they meet the other reporting criteria. And then also adding auto accidents on a public roadway if it occurs in a construction zone as being now reportable, whereas previously that had been exempt before. So those are the big changes on the reporting rule. And then I think next we talk about the wildfire smoke rule. Again, I'll just cover this very quickly. Hopefully you've heard about this. A season now to deal with the requirements of this rule. But also last summer, the Cal OSHA Standards Board adopted an emergency regulation regarding dealing with those hazards of wildfire smoke. And the concept here is that smoke from wildfire contains chemicals and gases and fine particles that can harm someone's respiratory health. And so really, as a specific example under a rule that we've already talked about today, the control of harmful exposures, which is kind of a generic rule covering, all sorts of different types of chemical and other inhalation hazards. This is a specific inhalation hazard that Cal OSHA wanted to really emphasize that there's a specific requirement, and they define some specific elements that they don't for some of the other chemicals that might be covered by the general control of harmful exposures. And that more specific definition is around thresholds for when it must be considered by the employer to be a harmful exposure, and therefore to take the actions that are required under the standard. And that's defined by and generally understood by the air quality index of a particular type of particulate matter that is associated with wildfires. And you can see the data points on these two slides. I'm not going to get into that level of minutia, but the idea is that there is a rule now that if the air quality index in the area where your employees are working exceeds certain thresholds, you need to take those actions that we talked about before under the control of harmful exposure standard and implement specific, implement engineering controls where feasible, lower those exposures, which might mean developing or changing the structures where employees work so that they are in enclosed structures with filtered air to protect them, or using administrative controls where engineering controls can't be sufficient to lower those exposure levels, like relocating the work itself to a different area of the state, changing work schedules, reducing work intensity, providing more breaks, things like that to address it. And then if you can't collectively address the exposures by engineering and administrative controls, then you turn to respiratory protection requirements, including N95 masks. And in fact, there is a requirement that they be made available by employers for voluntary use upon request by employees, and it can be mandatory use if you can't otherwise eliminate or reduce the exposure level. So that rule is in effect. And when you have in California, another season of serious wildfires, make sure that you understand you're paying attention to that. You're tracking the air quality index in areas where your employees are working and addressing that hazard. So I will now hand it over, I think, to Megan to talk about heat illness and workplace violence.
Thanks, Eric. So finishing up two topics that are in rulemaking. First up is the indoor heat illness prevention rule. So just as a little bit of background, and this is not a typo, there is an outdoor heat illness prevention rule, and that's been in effect since 2005. And the regulation essentially requires employers with outside workers to take 4 steps to prevent heat illness. One being developing and implementing an effective written heat illness prevention plan that includes emergency response procedures and other procedures. 2, train all employees and supervisors on heat illness prevention. 3, providing drinking water that is fresh, pure, suitably cool, and free of charge, so that workers can drink at least a quart an hour. And an important part of this piece is encouraging workers to take advantage of that as well. And then the 4th step is providing shade when workers require it, or when temperatures exceed threshold levels, encouraging workers to take cool down rest periods, and not waiting until workers feel sick in order to take these cool down periods. And as Andrew mentioned earlier in the program, this is a priority program, and as such, during a compliance inspection, you should expect Cal OSHA inspectors to ask about your employer's program and possibly evaluate it. And this is important context because, moving to the next slide, we have a new Cal OSHA indoor heat illness rule that's in the works. Back in 2016, Governor Brown signed and approved Senate Bill 1167, which directed Cal OSHA to draft and propose a heat illness and injury prevention standard for indoor workplaces. And this was supposed to be done by January 1st, 2019. There have been multiple discussion drafts. Cal OSHA has had multiple advisory meetings about the proposed rule. And when it was introduced, we saw similar provisions to the outdoor standard, which is why I took some time to go through that standard a little bit. So with this standard, you'll see similar provisions for things like providing water, having specific training and procedures for emergency response, allowing time for workers to adjust to higher temperatures, allowing cool down time in areas, and having a written plan. On the next slide, you'll see again reference to multiple revised draft standards that were issued in 2018 and 2019. And the little bit of background here is that there has been quite a bit of comments that came in earlier rounds, and there have been some significant changes. If you look at various drafts, there's been some changes in the threshold temperatures and some other changes along the way as well. So the draft that is out now, based on the April 22nd, 2019 revisions, is expected to go to the next step of rulemaking, and we're not expecting any additional pre-rulemaking changes to the draft. So generally speaking, the rule is going to apply to indoor work areas where temperatures reach 82 degrees, but as I'll mention in the next couple of slides, that can be kind of a complicated assessment on the temperature and the threshold in which certain things need to be done. But again, we do see the rule including the requirements for a heat illness prevention plan, heat stress hazard identification, having requirements and procedures for rest and hydration, first aid and emergency response. Again, a lot of the things that you'll see with the outdoor heat requirement, there's specific sections in the draft rule about exposure limits and control measures, and additional detail on training and record keeping. So again, we do expect to see a draft rule come out that's similar to the draft we've been reviewing currently, and kind of some of the questions that have come out of the process so far, and that we'll continue to try to answer if any further changes are made, or just moving forward in general, any additional guidance we might get to assist in implementing and complying with this standard when it comes into effect. Is one is kind of defining the indoor workplace. What is the indoor workplace? And in certain contexts that might be particularly tricky. For example, if vehicles and equipment are indoor versus outdoor, meaning if a given environment counts as being indoor or outdoor, but then also what you do when employees may be transitioning between an outdoor and indoor workplace, and kind of how to incorporate your now indoor heat illness prevention plan with your outdoor heat illness prevention plan if you are an employer who in fact has both kinds of workplaces. Another challenge, and these are referred on the next slide, that we see, which I alluded to, is calculating the temperature. Because there's certain thresholds that there's different temperatures that are considered based on certain factors. So you'll see here that determining when an employer is required to assess and implement control measures may differ depending on if you're measuring a temperature that reaches 87 degrees, or if you have employees who may be wearing clothing that restricts heat removal or working in high radiant heat work areas, there's a different threshold. So you'll see that 82-degree threshold where employees are wearing restrictive clothing. So kind of paying attention to these thresholds what matters in different contexts, and figuring out the best way to implement this, you know, kind of on the ground in real life. In the interest of time, there's certainly a lot more detail we can cover with the indoor heat illness rule, but moving on to the rulemaking for general industry workplace violence protection. This was mentioned, Eric kind of mentioned this earlier, that this is an area of particular importance in California. And so there is a kind of the context on this is that the California Department of Industrial Relations has reported that around 300 Californians die on the job each year. That was a 2016-2017 statistic. And assaults and violent acts in the workplace accounted for approximately 20% of all worker deaths in California in 2017. So this is definitely something that California is taking seriously, and something that Cal OSHA wants employers to be actively participating in. I won't dive into all the details of the regulation at this point, and something to note is that—
Megan, can I make one point? You know, there's a participant that actually made a very good point, that even though under the that we don't have an indoor heat illness standard right now, there is enforcement of the heat. There has been enforcement of indoor kind of heat situations under the Interim Illness Prevention Program. And so that's something we also see under workplace violence. So until this standard's in effect, you could have a scenario, for example, here where there is a workplace kind of violence episode, and they cite you for an injury and illness prevention program violation. But of course, once the standard is in effect, that will provide real teeth to the agency.
Great point. Thank you for that, definitely. Excuse me. We can move to the next slide on the workplace violence issue. As I was saying, we won't dive into all the detail of this draft regulation, but one part I did want to highlight at the outset is what is considered to be workplace violence under the draft standard is not limited to what you might typically think of as a workplace violence incident, and it does cover quite a bit. And there are specifically 4 types of workplace violence that are defined that cover everything from violence committed by a person with no legitimate business at the workplace. So this is kind of anybody who enters the workplace and commits a violent crime. The second would be violence directed at employees by customers. So those are intended patrons of the workplace, people you would expect to be there. The third type is violence against employee by a present or former employee, so kind of a disgruntled former employee situation. And then 4 would be violence committed in the workplace by someone who doesn't who doesn't work there, but has been in a relationship with somebody working there. Now, in case you're wondering, you've heard of a workplace violence standard before, and there is a current rule in healthcare, and it applies fairly broadly, and it's in recognition of a known increased risk of workplace violence in certain healthcare settings. So you can imagine that in the case of certain psychiatric patients, or in certain cases of substance abuse, or in other contexts, that there may be an increased risk in the healthcare setting. So the workplace violence rule for general industry contains calls for procedures in a number of areas, and you'll see here a whole slew of requirements for written programs. So you have things like it calls for specific employee union participation in developing the plan, coordinating the implementation of the plan with other employers, So again, really asking for employer and employee participation in the development of the plan. Calls for specifically how to receive and respond to reports of workplace violence, ensuring that supervisors and non-supervisors are complying with the plan, communicating with employees about workplace violence matters, responding to workplace violence emergencies, training, specifically going through a hazard identification, including and correcting hazards in a timely manner. This, could include periodic inspections to identify unsafe work conditions or work practices, and then procedures to evaluate any hazards that have been identified. There's post-incident response and investigation, and a periodic review of your plan. So there can be quite onerous requirements for implementation of this plan, but I think that it seems that the intent of it is really to have kind of everybody involved in the process, so that there's information coming from people at all levels of an organization contributing to the plan. So again, if this is promulgated, the general industry workplace violence prevention rule is going to apply basically to all facilities with few exceptions. And the exceptions are laid out currently as, of course, sites that are covered by the healthcare rule, and then sites operated by California Department of Corrections and Rehabilitation, certain law enforcement agencies, and certain facilities. There's a very specific exemption for certain California Department of Developmental Services that are scheduled to close by 2021. We had one final slide, and if we're not able to put it up, it kind of just summarized the history of the rule at this point, and the fact that we are expecting a further revision underway. But kind of the questions that we've been noodling with for those of us following the issue is, whether, and we've certainly helped clients in the healthcare industry develop a plan for their workplace violence program. So the question here is the same kind of level of analysis going to be required kind of for every type of individual site every type of individual business, or even within a business, every type of every individual site? Or are you going to be able to have kind of a general plan that could apply in a more general fashion? We certainly recognize that if a site has a particular increased risk, let's just say you could think of a retail establishment that's open late at night in a high crime area, you could see there might be a more tangible increased risk of workplace violence there. But how do you handle kind of a typical office setting where you might not have that tangible increased risk? And remains to be seen what the rule will look like, especially if there are significant revisions to it. And then if it's promulgated, we'll see if there's, as CalOSHA has done with other standards, if there's further guidance, or perhaps even sample plans that can be adapted, or whether employers will work with their safety teams and their counsel on developing their own plans. I think with that, I can pass it back to Eric to finish off the lovely discussion we've had this afternoon. Thank you, everybody.
And thanks, everybody, for joining us. We do have a bunch of resources available. We have been drinking from the fire hose on COVID-19 issues, primarily in the Fed OSHA states and here in California. And we've got an FAQ page up on our website that we're updating regularly. And now it's like a 60-page manuscript at this point, and it's broken down by category. So I'd encourage you to check that out if you are managing and dealing with those coronavirus issues in the workplace. We also have, as I mentioned, our webinar series, and this was the April edition of the OSHA webinar series this year. Take a look at the schedule here on this slide. I encourage you to join us for the rest of these. We do try to keep them to around an hour and 10 minutes, and sometimes they turn into feature-length films, and I apologize. But this one was, our regular program. Then we added in this giant, hopefully once-in-a-lifetime crisis to address as well. But check out the other topics and plan to join us for those. And then we also have our blogs, the OSHA Defense Report and the Employer Defense Report. And we are putting up, in addition to the FAQs on our website, putting up, longer sort of, almost white paper type of articles on the blog right now, almost exclusively about COVID-19 issues, whether it's respiratory protection and face coverings and record keeping and reporting, guidance in different states and different industries. So definitely check that out. And I really appreciate everybody joining. Tried to address most of the questions as they came up during the program. If there's others that it does not look like we addressed, we'll take a look at those and respond to you directly by email afterwards. But thank you everybody for joining us. We are going to make the slides available to everybody within the next day or two. We will get you a copy of the slides and a link to the recording that we did. And if you have any questions at all, hopefully you could tell we're big nerds about this stuff. We love talking about it. We love hearing your experiences with it. And then certainly if you have questions or any issues that we can help with, we'd love to be a resource for you, and we'd love to be a partner with you in managing these issues in your workplace. And we've got a really wonderful team out in California working on these issues, supported by what I think is the deepest bench of true OSHA specialists anywhere in the country. So we'd love to partner with you on these issues. So thanks everybody. Stay healthy, stay safe, and stay sane through this really, really remarkable time. And nice talking with you today.